So welcome everyone. Thank you for joining us for the fourth installment of the Department of Correction Insider webinar series. Our topic today is Probation and Parole 101. Slide. My name is Heather Zwickert. I am the Chief of Planning, Research, and Reentry with the Department of Correction, and I'll be moderating today's session. Planning, Research, and Reentry is a specialized unit in the Office of the Commissioner that leads the department's data collection and analysis efforts, facilitates strategic planning, oversees the department's accreditation and compliance, and provides project management for multi-bureau initiatives set by the Commissioner. The unit has also been assigned the task of expanding and improving prisoner reentry initiatives within the Department of Correction. Today's presenters are Bureau Chief Terra Taylor and Probation and Parole Director Melissa Kearney. Chief Taylor joined the department in 1997. She became a probation and parole officer in 1999 and specialized in domestic violence and sex offender supervision. She was promoted to P&P supervisor in 2011, operations administrator in 2014, and regional manager of the Dover probation office in 2016. Chief Taylor was named the statewide director of probation and parole in 2017, where she focused on new initiatives to improve officer equipment, enhance community outreach and education, and improve communication and employer relations. In 2019, Chief Taylor was appointed as Deputy Chief of the Bureau of Community Corrections, and in 2021, she was appointed as Chief. The Bureau of Community Corrections oversees probation and parole, pretrial services, electronic monitoring, work release and violation of probation centers, and the statewide Community Corrections Treatment Center. Chief Taylor has a bachelor's in science and criminal justice and is a graduate of the National Institute of Corrections Management Development for the Future program. Director Kearney joined the department as a probation and parole officer in 1995. She was promoted to probation and parole supervisor in 2001 and specialized in domestic violence and pretrial supervision. Director Kearney established the Victim Services Program for probation and parole in Newcastle County in 2001, a program that has since been expanded statewide. In 2020, at the start of the COVID-19 pandemic, Director Kearney was promoted to regional manager of the Cherry Lane Probation and Parole Office, which is the department's largest probation and parole office. She worked collaboratively with the courts and other stakeholders to continue to coordinate the participation of probation and parole officers in remote court proceedings and to ensure that services continue to be provided to probationers and to the community. Director Kearney was promoted to statewide director of probation and parole in 2021. She's a member of the department's critical incident stress management team and serves as the deputy compact administrator of the Interstate Commission for Adult Offender Supervision for the state of Delaware. She has a bachelor's of science degree in community and family services. Thank you, Chief Taylor and Director Kearney, for presenting for us today.
Good afternoon, everyone.
Good afternoon.
Today's agenda will include information on the role of the probation and parole officer, getting started on probation, types of supervision, what to expect while under probation supervision, specialized probation caseloads and task forces, services offered by probation and parole, and how to complete a probation term. We will give you information about ways to get involved and connected, and at the end, we will have a period for questions and answers. We do ask that you submit your questions through the Q&A box on the bottom of your Zoom screen. Please use that, the Q&A box versus the chat box to ask your questions. It's easier for us to keep track of them that way through the Q&A section. We'll select some questions that have been submitted at the end, and I will pose them to our presenters. Due to the large number of attendees that we have today, I think we are 41 people on right now. We probably won't be able to get to every question, but we will respond to as many of the unanswered questions afterwards by email if we can. Please keep in mind that we won't be able to answer questions about specific probationers or specific probation officers during the webinar. We can answer general questions, but we will provide you with information on how to get in touch with someone who might be able to answer questions on specific cases or specific people. The webinar is being recorded, and we'll make the webinar and the PowerPoint available after the webinar. And we'll also supply certificates of attendance for those who stay tuned in for the entire webinar. So as long as you are on through the end of the webinar, we will be able to provide you a certificate at the end. During the course of the webinar, we are going to also do some polls to keep things interactive. Your answers for all the polls are anonymous, and we will debrief after each poll. So for the first poll question today, we'd like to get a sense of who is joining us. So as a check-in, we are going to invite you to click on the poll that should be appearing on your screen right now and tell us which stakeholder group best describes you. DOC employee, other state agency employees, nonprofits, community members, students, for-profits, or others. And we'll give about a minute for people to answer this question. I appreciate everyone responding. We have a great response rate so far. We'll give it just a few more seconds. All right, and I'm going to go ahead and there. So I'll go ahead and share the results with you too. So we will see today that most of our attendees are state agency employees. We do have quite a few DOC employees who are attending today, which is great. We always like to make sure that staff throughout the department are aware of all the different things that are going on. And super exciting that we have a lot of people from outside DOC who are also here to participate. So again, thanks everyone for coming. Now, let me stop sharing the poll. And that stopped sharing. Mm-hmm. Yeah, okay. So I will turn it over now to Chief Taylor and Director Kearney to get us started with P&P 101.
Good afternoon, everyone, and thank you for joining. I'm happy to see so many people participating. We're almost up to 150, so that's great news. I wanted to start off today's presentation with just giving a brief overview of the different locations that we have for probation and parole. Starting off in Newcastle County, we have 2 probation offices. One is in the northern Newcastle County region. Manager there is Marcus Thompson. Then in the southern Newcastle County area, we have a probation office that is typically referred to as Hare's Corner. And Jeff Boykin is our regional manager there. In Kent County, we have 1 location in Dover. Keisha Winchester is our manager. And in all of Sussex County, Dave Johnson is a regional manager, but we have a Seaford office and we have 2 Georgetown locations right side by side. In addition to our main district offices, we have 2 intake offices located at the courthouse in Newcastle County and in Dover Courthouse, Kent County Courthouse. Next slide. Next is our mission statement, and there's 3 primary points to Probation and Parole's mission statement, starting off with promoting public safety through the supervision of offenders placed under community supervision with the Division of Probation and Parole. Then we have our programs and treatment services that promote self-sufficient law-abiding behavior. And last but not least, our efforts also are to support and make the victims whole in accordance with Delaware law. Next slide. Thank you. All right, the Statutory Authority of Probation and Parole. It is defined, our powers are defined in Title 11, Chapter 43, but for our presentation today, I would try to keep it as simple as possible. Basically, probation and parole officers have the same powers as a constable, and the powers of a constable are clearly defined in Title 10, Section 2705. It gives the powers and duties of constables. In addition to that, probation and parole officers may conduct searches on individuals under probation and parole or parole supervision, and they shall execute the lawful orders, warrants, and other orders directed by the courts, judges, or Board of Parole. Thank you. The roles of probation and parole. One will typically say that probation and parole officers wear many hats, and that is extremely true. And one day a probation and parole officer could start off as a counselor, and then within a couple hours later, they have more of an enforcement role, or maybe it's surveillance. Maybe it's they're bridging the gap between one of our probationers and possibly a community service agencies, connecting them with services that are necessary for a successful reentry. And many times they also act as an advocate, helping sometimes with domestic violence, we will help them through kind of navigating through the system. Maybe it's requesting a protection from abuse order, but the range of roles that a probation officer fills it can range for extreme from one typical day. And then many of you might already know this, but there are, for the Department of Correction, there are different levels of supervision. I'm going to start at the most restricting, we refer to it as level 5. That is your incarceration. Then for level 4, for the Bureau of Community Corrections, that includes home confinement. It can also include work release facilities or violation of probation centers. And then level 3 supervision, that is our highest risk level for supervision. Level 2 is our moderate, and level 1 is low. And when we get a little bit further along in the presentation, we'll be able to explain how our risk needs assessment that we use connects to the level of supervision for probation. Different types of supervision. We commonly refer to our agency as probation and parole, but the reality is that it also includes pre-trial supervision. So starting with the most common probation, those are typically our direct sentences from court. Sometimes it can be deferred after a period of incarceration. And then we have our parole, which is an early release from level 5, placing the individual on parole supervision for the remainder of their level 5 sentence.
We're going to get into an explanation of each of these 4 categories as well as we move on in the presentation.
Thank you, Director. And then we have our interstate supervision. Delaware is just one small state, and oftentimes offenders may be arrested and convicted in a particular state, but they may reside in another state. So there is an Interstate Compact agreement that, again, we'll go into greater detail later on in the presentation. But what that does is it means Delaware could be supervising a probationer that was actually sentenced in another state, but we have agreed to accept supervision of that state, and vice versa. And then our pre-trial defendants, those are pre-adjudication, and they are supervised by our staff as a condition of their release or bail. Next slide.
Tara, we're going to stop now for our next poll. So I will be launching poll number 2. So this question is, as we move on to start talking more in detail about probation and parole, the question is about how many people are currently under probation or parole supervision in the state of Delaware. So we have 4,500, 8,500, 15,000, and 25,000. If everybody wants to put their answer in, we'll give it about a minute. A couple people still chiming in. All right, I'll wrap it up in just 1 second. All right. So the most common answer that we received was 8,500 people currently under probation and parole supervision, 45% of you, and fantastic. That is actually the correct answer. So as of, I think I pulled that number October 20th, there was approximately 8,500 people on probation and parole from level 1 restitution only to level 4 home confinement. And our presenters will go into what those things specifically mean a little bit later in the presentation. But now I will turn it over to Director Kearney to talk about the probation and parole population over the last several decades.
Yes, thank you. So you can see from this chart, this gives you kind of a visual of the number of probationers we've had starting in 1979 to the year 2020. And you can see there's some peaks and there's some valleys, and a lot of times there's legislation that gets passed that's a direct result of our probation numbers. We need to find a way to do it better, to focus on those people that are high risk, and those are the people we need to spend more resources on. So if you look, the first, I don't know, does the slide come on that has like arrows, Heather? Yes. So truth in sentencing was the first act to kind of change how we did business at probation and parole. So truth in sentence involved abolishing the parole system. So it limited the amount of good time that people get while they're incarcerated. And so that had an impact on our probation numbers. And then the next one was the Probation Reform Act. We often call it Senate Bill 50. This is where some changes that were made that include probation sentences could have run one right after the other. We call it consecutive terms. This law actually changed it where multiple probation levels can run at the same time. So they're run concurrently rather than consecutively. Oftentimes people are on probation for multiple offenses. So it essentially reduced the amount of time people are serving supervision. It also put term limits on some probations. So those who are sentenced to violent felonies, there was a 2-year maximum probation sentence that could be imposed. And for felony drug offenses, it's 18 months. And most other crimes, it was a year. So a year of probation term. So prior to this, people can be on for 5, 10 years. And it was harder for them to get out of the system. Senate Bill 50 also allowed us to resolve violations without always submitting a violation to the court. We could handle things administratively and resolve technical violations without having to take action against the person in front of the court. And it also changed the way we do business in that we are doing assessments now on people, and we are determining their risk and needs, and trying to, again, put resources where we need to focus on those people that are higher risk. It also created level 1 restitution only, which is a specialized caseload where it's simply for a collection of restitution. The next one is Senate Bill 226, the Justice Reinvestment Act. So that changed how we calculate conditional release sentences and provided good time on probation sentences. It also allowed us to discharge people without the court order, and we'll go over that a little bit. It's called earned compliance credits, so we can quickly move people through the system. Again, graduated responses and graduated incentives, and we'll go over that as well, was part of the Justice Reinvestment Act as well.
Okay, now, so just want to give you guys sort of an idea of what it looks like when someone has to sign up for probation. We have 2 traditional ways, one through intake, which is our intake offices. Those are our non-incarcerated individuals. They may have been sentenced in court, They will get their sentencing order instructions and then directed to report to the intake office, either at the courthouse or at the probation office. Then we have institutional release, sort of the same process, except location looks a little different. We have our institutional release officers that will go into our level 4 and our level 5 facilities. They will meet with the probationers, sign them up for probation, and give them their instructions. Okay, so some of you may wonder, like, how do we determine who is assigned to what particular officer? And it's based off a few different factors, primarily one being the county of the residence or the proposed residence. The next would be the level of supervision that he or she is assigned to from the court. So if they live in Kent County and they are level 2, they would be assigned to a level 2 officer in our Dover Probation and Parole Office. The next thing we take into consideration is caseload specialization. And we will kind of go into what those caseload specializations look like a little later on in our presentation. One of our typical caseload specialization could be domestic violence, sex offender, or electronic monitoring.
And they're divided up in Newcastle County. So there might be, so that, say, for example, the domestic violence unit is located at the Harris Corner Probation Office, but the sex offenders are located at the Cherry Lane office. So in Newcastle County, those specializations, even if a person lives in close proximity to one of those two locations, they may be assigned to the other office based on their specialization.
So whether or not the probationer is signed up for probation at our intake office or our institutional release officer goes into the facility and meets with them, some of the basic information that will be collected from them is going to be address, level of supervision, and caseload specialization. Okay, so a little bit more about what that intake process looks like. In addition to the officer assignment, every probationer will be given reporting instructions. This will all be written on a reporting notice that will include their assigned officer's name, the address and phone number to that particular assigned officer, and any specific reporting instructions. It may be a day or a time, or it could be a time frame. The conditions of supervision will be read to everyone. There will be an opportunity for questions if they have questions, and then there will be a signature at the end acknowledging their understanding. And then finally, there will be an overview of any sort of financial obligations from court costs, fines, restitution, possibly supervision fees, and that acknowledgement form is also reviewed and signed.
All right, next. So these are the standard levels of standard conditions of supervision for levels 1, 2, and 3. So again, like Chief Taylor said, anybody who gets assigned to probation gets a copy of these conditions so they know what their expectations are. Oftentimes, even though this documentation is reviewed by the intake staff, it is also reviewed by the officer assigned to that case, because the officer might, want to clarify something specific to, say they're reporting, or it's something that specifically can be answered by that assigned officer. So condition number 1, basically they have to stay out of trouble while they're under supervision, and that includes an arrest. So back in, before some of those reforms happened, it used to say the person had to be convicted of a new offense. But now we go by the condition 1 is that you just must not commit a new offense. So that includes an arrest. They have to report any new arrest, convictions, or police contacts within 72 hours. And we say, even if you're pulled over for a speeding ticket, just to clarify, you should report everything to your officer, because if there's something significant that we need to know about, we need to make sure that they are clear in what the guidelines are. In condition 3, they have to report at such times and places as directed and permit the officer to enter the home or place of employment. They also need to get permission to leave the state of Delaware. They actually have to sign a travel permit, and we need to confirm and verify their travel and the reasons why they're travel, and we check on compliance before one is granted. And there are certain restrictions for certain types of offenses. However, generally, it's a discussion between officer and probationer about their travel and what the reason is. And if it's a pro-social reason, generally it's authorized. There's limits to that too. You must report any changes of residence or employment within 72 hours. So they need to make sure they're advising their officer if they move. Next slide. Condition number 6 says that you must not be own, possess, or be in control of any firearm or deadly weapon. So even if a person is on for a misdemeanor, they are still prohibited while they're on probation from having access to weapons, having weapons in their home. Condition 7 says that they must not possess or consume a controlled substance or other dangerous drug, and they are subject to random testing. So a person can be on probation for a non-drug offense, and the officer can still submit them for testing. You know, sometimes there's reports that come from the community, you know, it wasn't on the radar, it wasn't part of the original conditions that they had a substance abuse problem, but someone from the community calls and says this person is using this or that. So oftentimes the officer will follow up and do a drug screen and go from there. Condition number 8 says they have to pay a $200 supervision fee. And condition 9 is they must comply with any special conditions imposed at any time by the officer, the court, or the board of parole. So generally, and you could go to the next slide. Okay, so this is the addendum. So those first set of conditions only apply to 1 through 3. So this addendum is specific for level 3 probationers. It's a more intensive level of supervision. There's more contacts, so there's more conditions that are placed on them. So they have to be working or in some type of job training. And if they aren't working, the officer could impose community service. They also have to abide by a curfew, and generally the curfew is 10 p.m. to 6 a.m. Now, if someone is working, say, for example, a night shift, as long as that documentation is provided to the officer, they can modify their curfew based on what their work hours are. We just need proof of that.
And Missy, I just wanted to add to this. These 13 conditions are not something that the Department of Correction created on their own. These 13 conditions are outlined in the CENTAC bench book as you know, what probation should use as their conditions of supervision. Likewise, there is additional special conditions specific to sex offenders that can be imposed by probation as well, depending on the case. But again, these are outlined in CENTAC bench book.
So special conditions, as I stated in condition number 9, it can be imposed at any time by the supervising officer, the court, or the board of parole. So most of the time people come away from court with their sentencing order that stipulates special conditions that the judge imposed. And these can be no contact orders, no contact with specific individuals, co-defendants, specific locations. It could be treatment programs that are ordered, substance abuse, mental health, DUI courses, parenting courses, DVCC certified programs, which are programs that meet the quota for domestic violence treatment, pay costs and fines, obtain a GED, high school diploma. Now, if, say, for example, an officer is supervising someone and, you know, the community says this person is using opiates, and the officer follows up, does a drug screen, and they are in fact positive, and the court wasn't aware, and that wasn't part of the original order, the officer can impose a substance abuse evaluation and treatment as a result of that positive urine. But the officer is also following up with the court and writing a progress report to the court and explaining why we are asking for the court to impose this as a special condition. So so that we can enforce it as well. But it's not arbitrary. There's a reason that we have to justify imposing a special condition. All right, we have a couple case studies for you where people are in this point of their probation based on the presentation so far. So go ahead, Sarah.
I'll start us off. Basically, it's just to kind of give you guys an idea, and we'll use these same two names and kind of follow us through as we move forward through the presentation. So we're starting off with Jane Doe, and Jane Doe is serving a sentence for dealing drugs. She was sentenced to 2 years of level 5 treatment at DOC discretion, and then flown down to 18 months of level 3 afterwards. Jane was seen prior to her release by probation and parole, meaning a probation and parole officer, an institution release officer went into the facility to meet with her, to give her her officer assignment, to give her reporting instructions, and to go over her conditions of supervision and any financial obligations. Jane's special conditions are to comply with treatment in the community and pay off all of her financial obligations in full. So that's just a descriptive of what the intake process would look like with Jane Doe being inside a facility for serving her sentence.
All right, and I have Matt Smith. Matt Smith, he's out on bail, so he got arrested and he got released. And the charges were pending, and he finally went to court. He went to Superior Court and he got sentenced to 2 years level 3 for robbery 2nd degree. He reported to intake at the courthouse, and he got assigned to an officer and was given reporting instructions. His special conditions are to have no contact with his co-defendants, to obtain a GED or high school diploma, and to have no contact with the area where the robbery occurred. All right, so as Chief Taylor said, we wear many hats when it comes to what we do. And it's not just the enforcement piece, it's also the counseling piece. We try to help people, we try to reintegrate people back into the community. We do interviews and assessments of people. We use EPICS, which is Effective Practices in Community Supervision. It's a way of, it's basically a tool for officers to effectively communicate with offenders, to try to work with people, to create a positive working relationship between officer and offender. And it's a very structured approach. In addition, we do assessments, we determine risks, needs, we come up with supervision plans to try to point them in the right direction of pro-social behavior. We conduct office visits where, they report in, they check in. Oftentimes we're doing urine screens. We may be checking up on referral statuses, where they are in certain programs. Oftentimes phone calls are being made while the offender is in the office with us, confirming what's going on. If they're having trouble, say, making an appointment, we can, put the treatment provider on speakerphone and get the process moving. We conduct home visits where we are verifying the residents, but we're also looking at the home environment and the people that they live with, their family, their relationships. Again, referrals based on their treatment needs, based on special conditions. We attend various court hearings. So we not only attend our violation hearings and prosecute our own violation hearings before the judge, we also make bail recommendations. If somebody needs to be incarcerated because their violation is very serious, we can, go to the court and make a presentation as to why we are asking for a certain level of bail. Oftentimes our officers, if they're involved with new criminal charges, they have to testify in suppression hearings. And they also assist offenders after discharge. Oftentimes people will come into our office and they say, yeah, I need a letter saying I complied with probation. I'm trying to move on with my life. I'm trying to join the military. And we often provide that information.
So Director Kearney talked a little bit about our risk needs assessment, and our primary risk needs assessment that we use is, we will refer to it often as the LSIR. And what that stands for is level of service inventory. The R is for revised. You know, one of the things that we have tried to really improve upon is using evidence-based tools to help drive how we supervise our population, rather than just going off of our gut or a court order, or you know, maybe it's looking back at the case history. So what this level of service inventory revised will take into consideration are 10 different subject areas, starting with their criminal behavior, any drug or alcohol use. We'll take a look at their family and marital relationships, companions. What are they doing on their free time? What's their education and employment history look like? What's their emotional status and their personal views, their attitudes towards the crime that they have been convicted of? The LSIR consists of 54 questions. It takes about 45 minutes or so for the officer to sit and meet, go over the questions, gather the answers. It's done within the first 45 days of supervision, so that we have that assessment information. And then it's done every year after that, if needed, if there's even enough time on the probation sentence. And what we'll do with that information is we'll take that outcome, that level, that risk needs level, and whether or not it shows up as high, moderate, or low, that drives how we supervise our probationers. Next slide. Just to kind of give you guys a snapshot of what our LSIR, approved LSIRs look like at probation and parole in 2020. Now keep in mind, with COVID-19 and things being a little slower, our population numbers have decreased slightly. But total LSIRs approved in 2020 were a little over 3,000. And what the graph will show you is how the numbers were broken down from high, which we would supervise as level 3, moderate, which would be supervised as level 2, and then our lows, which would be our level 1s. Typically, in a year, the number of LSIRs that we have approved have been around 4,000, possibly a little bit higher. So last year with COVID, like I said, the numbers have decreased just slightly.
All right, office visits, we kind of went over this already, but these office visits that we have with offenders are very purposeful. We try to develop a rapport with them. We try to get information from them. We try to, elicit what's going on in their lives. Sometimes you're dealing with somebody where, there's little to talk about. They're complying, they're just moving along. And the other times you're dealing with somebody who might be in crisis at that moment, and you have to spend a long time with them, and you might have to call mobile crisis and do some immediate intervention. So this list is some of the things that we do when we conduct office visits. So I'll just discuss police contacts, that sort of thing. Home visits. So we're also verifying the residents, but a big purpose too is to make sure they're in compliance and to develop that rapport with their family members, because they can be a good resource for probation officers. I always, when I was a domestic violence officer, just always said you're visiting the scene of the crime most often, because if they're still in a relationship, you're going there, you're making sure there's no signs of any new domestics going on. So you're meeting residents, you're engaging their support system, you're making sure you're just seeing their home environment in general, and it gives you a good perspective of what they're dealing with and any challenges they have.
So we'll stop here and we'll take another poll. So Director Kearney just talked about the purpose of home visits for probation and parole. So we're going to pose a true or false question to you now. So the question is, true or false, you are not permitted to be homeless while on probation. So we'll give people a minute to answer. really appreciate wow, people are responding quickly. I really appreciate the feedback and everyone participating. All right, we'll just give it another couple of seconds. All right, and I will close the poll and share results with you. So 60% of you voted that it is false, that is a false statement, and that is accurate. It's actually, you guys know a lot about probation and parole. So we find that it's often a common misconception that people believe that you aren't permitted to be homeless while on probation. So I'm excited to see that the majority of you knew that that was not true. Dr. Kearney, can you talk about what someone should do if they find themselves without a place to live while they're on probation? And if there are any specific circumstances where you couldn't be homeless while on probation?
Yes. So we try, again, to assist people. So if they are reporting homeless, we try to give them some resources. We have housing vouchers. There are avenues we can take to help people find shelter. If a person is reporting homeless, there's the Sunday breakfast mission. There's other facilities that we can refer them to. If a person is reporting homeless, say they're bouncing from bed to bed, we just make a requirement that they report into their officer every time they change their residence. So if they don't have stable residence, they are to contact their officer every night and at least leave a message as to where they're staying until we can, work together to try to come up with some stable solution to the problem. The only person that can't be homeless is somebody who, of course, is sentenced to home confinement. We would then have to modify the order and do some sort of level 4 alternative if that was the sentencing order and the person was homeless.
Great, thank you. So the key is communication, right, when you're in that situation.
Absolutely.
Yes.
Right, graduated responses, something that we have always done at probation and parole, not something that we have always documented in a mechanism where we can pull for data. So graduated responses will consist of both incentives and sanctions. Obviously, the incentives are encouragement for the compliant behavior, and then sanctions would be for the non-compliant behavior. Some of the examples that I can give, a sanction could be and if they're for technical violations, so like maybe it's a missed office visit or a missed treatment provider, or maybe it's a combination of 2 or 3 technical violations, and the officer could then impose additional community service as a graduated sanction. Or maybe it's enhanced curfew hours. And examples of incentives could be decreased curfew, less reporting requirements, maybe it's, taking, maybe it's a weekend spending the night at a family member's house or something of that nature. But we've done it for years. We just haven't done the best at documenting. And now it's more recently we are, and we'll be able to take a deeper dive into some of those numbers and show you guys what those look like. So as you can see, this is graduated responses for compliance. In 2018, our numbers were very low. Again, it's not because we weren't using graduated responses, it's because we were not documented using the correct method. And we created a new module specifically for capturing this information. So that was just at the beginning stages of that new module. And then you can see in 2019 and 2020, the graduated responses that were imposed and documented were over 2,000. Likewise, graduated responses for non-compliance. In 2018, just over 3,000. 2019, we peaked 4,000. In 2020, just below 4,000. And again, we did have decreased numbers due to COVID.
So we have a lot of resources available for probationers, and a lot of them, we have contracts with like Gateway and the Center for Justice. So a lot of our resources are in-house. Some of the resources are generated by probation officers themselves, you know, getting a clothing closet together at their facilities, and you know, providing other support services for probationers. Again, victim services is something that is near and dear to my heart, and I think I'm glad to see that it's now a statewide program that's being offered in each domestic violence unit. So these are just some of our resources that we use.
All right,
All right,
back
we're
to
gonna-
our case
Yeah.
study.
We're going to check in on Jane and Matt and see how they're doing.
Exactly. So if you guys remember, we had Jane Doe. She was on for drug dealing. She was sentenced to level 5. And then she had probation to follow. Our institution release officers went into the facility to meet with her to give her reporting instructions. Now Jane is out, and Jane reported to probation. She had her risk needs assessment, the LSIR, that was done within the first 45 days. She did score as high risk, so she remains on level 3 probation. But Jane goes and meets with her officer, provides an address and all the other required information. She's referred to treatment. She finds employment. She continues to report. She's consistently going to treatment. Jane is then given a graduated response, and this, in this particular situation, is a graduated incentive to modify her curfew to allow her to take her children to a late movie one night. So that's another example of how compliance leads to graduated incentive. And then that's when this example of the graduated incentive is modified curfew.
And Matt's not doing so well. So he reported to his probation officer, and the LSIR assessment was done, and he was originally sentenced to level 2 by Superior Court for the charges, and he is bumped up to high risk. So he has moved from level 2 to level 3. He meets with his officer and he provides an address and other required information, and is referred to case management and employment and education services. His officer goes to verify his residence and is told that no one lives there by the name of Matt Smith. Matt reports to his probation officer inconsistently, so he doesn't show up when he's scheduled to report. He missed 2 curfews, and he is given a graduated sanction of 30 days of GPS supervision. So the officer wrote to the court and said, in order to maintain a level of compliance, and I can't figure out what Matt's up to, can I put him on 30 days on electronic monitoring so that I can monitor his whereabouts, and it's also a graduated sanction instead of a violation. All right, so yeah, this is just the intro to, so we're going to talk about specializations and about the task forces. And the P&P Reentry, each district office has in-reach coordinators, and what they do is they go into the institutions and they meet with those people who are, for females, they have 6 months or more of a level 5 sentence, and for males, it's 1 year or more that they've served as an incarcerated person, and they are about to get out. So they are going in and basically trying to set them up for success. So they're trying to come up with transition plans, try to, if they need shelter services, we try to set those things up before they get released. A lot of times there's documentation that's missing, such as birth certificates, social security numbers. So we try to get all of those documents that they need to start working and start succeeding in the community. Start to get the ball rolling before they get out. And I was just talking to the in-reach coordinator supervisor, and he went over to BWCI with his in-reach coordinator and was reminding them, some of them have lengthy sentences, like you have to start remembering phone numbers and that sort of thing, because maybe by the, when they were incarcerated, cell phones weren't a thing where everything, or cell phones are, people aren't used to memorizing numbers, and they might need to do that now because, they've been out of touch with people. So they try to, get them to ease into the community and succeed. Pretrial supervision. So we talked a little bit about that. And again, if someone is arrested, and a lot of times you'll read in the paper that, something horrible happened and the person got released. A lot of times if it's bad enough, they'll impose cash bail. There's certain levels of offenses that they will impose cash bail, but oftentimes pretrial supervision is something that's imposed. Pretrial is slightly different than probationers. They have more liberties than a probationer who's convicted because they have not been convicted yet. So these are the pretrial conditions that they have to comply with. And as you can see, they're less intensive than those who are convicted. So they have to, stay out of trouble. They have to report at such times and places directed. They need to report any new arrests, any changes of residence. They also need authorization to leave the state of Delaware and have to comply with any special conditions. And a lot of times, a judge will order pretrial supervision in addition to some sort of counseling. And they are on that supervision term until they go to court to actually be sentenced on that case. Yes.
We'll stop here and we'll launch another poll.
Okay.
So our next question is, the Director Kearney has been talking about pretrial supervision as a condition of release. So the question we're posing to you is, the use of pretrial supervision as a condition of release by the courts has increased or decreased over the last several years? We'll give everyone a minute to answer. Lots of answers coming in. Thank you for that. Just a few more seconds. And then we will go ahead and close out the poll and sharing results. 91% of our participants indicated that the use of pretrial supervision has increased over the last several years. And that is absolutely correct. It has increased significantly over the last several years. And Missy, if you would like to talk a little bit more about the active supervision cases for pretrial supervision.
Yes. You guys are right on target. Of course, our numbers are increasing by the day for pretrial. And one of the reasons for that, if you look in 2019, bail reform happened, and that changed the way the courts imposed bail. There were only certain offenses, again, where cash bail is imposed. So that reduced our prison detention population, but it increased our pretrial supervision numbers. So that happened, and you can see that the numbers start to increase. And then, of course, we're going to blame COVID for the rest of the increases. So, there was a period of time where the judges were less likely to incarcerate people, and alternative to incarceration is to place them on pretrial supervision. A lot of times, some of the maybe worse cases, they imposed some kind of electronic monitoring while they were on pretrial supervision. And part of the reason for the increase too is due to the fact that the courts have slowly reopened. So we don't close these cases out until again, they go to court and there's a final disposition, and then they're generally sentenced to probation after that. So we because of the slow rate that the courts have reopened, we've been unable to close some of the cases. So we have a large population that are coming into pretrial supervision, but less that are being closed out because of the slow pace of the court reopening.
All right, earlier we talked about some caseload supervision specializations and sort of how that drives officer assignment. I wanted to go into greater detail, like what do those caseload supervisions look like? And they can change. I'm going to start at the top. Electronic monitoring. I want to be clear with the group that electronic monitoring covers three, and I'm going to go into, we're going to discuss it a little bit later on. It's going to cover three different types of electronic monitoring equipment. Each have very distinct roles. We have home confinement. You must have, like Director Kearney said, you must have a residence for home confinement. You must have approved host. You wear the anklet. Basically, the home confinement device just says whether that probationer is either in the house or out of the house. That's all it does. And the system will put the curfew hours into the system. If they leave the home outside of their confined hours, it will send an alert to our 24/7 monitoring center. So home confinement, all it does, ins and outs, it's based off of the schedule that's put into the system. You must have an approved residence for that type of equipment. Then I'm going to jump to GPS. GPS is an anklet, again, that is worn, but it gives GPS points constantly. It's not a level of supervision, but like home confinement is considered quasi incarceration. GPS could be on a low risk offender, a moderate, a level 2 probationer. It's going to tell us where he or she is at 24/7. We can put exclusion zones. So let's say it's typically for cases where you have either an area that you want to restrict him or her from, or maybe it's a victim's residence as such. We can put an exclusion zone around a particular area. And then when that particular probationer either enters that exclusion zone, the 24/7 monitoring center will then get an alert on that as well. Then finally, we have our alcohol monitoring. The alcohol monitoring was an anklet. We've transitioned to a new device. It's basically a portable breathalyzer. A lot of, most of our cases are either through DUI courts or DUI thirds and above. For specializations, we also have mental health court. We have sex offender supervision, domestic violence, which we've talked about a little bit. R2R Aftercare. The R2R stands for Road to Recovery. We love acronyms at the Department of Corrections. So R2R Aftercare is somebody has completed the substance use disorder treatment at either level 5 or level 4. Our providers has deemed that they continue to need aftercare treatment while they're on probation. Their care is then transferred to aftercare and monitored by probation with a partnership with the provider. We also have DUI court, veterans court. A new specialization is group violence intervention. It started in Wilmington and Newcastle County and is now expanding to Kent County. It's specifically for group violence shootings in that particular area. And then we also have our reentry court.
All right. Oh, is it poll time?
Yeah, I think it's full time. So before well, actually, you know what? Do you want to talk just briefly about the Interstate Compact and then we'll launch that poll? I'm sorry.
Okay. All right. So as we talked about, there are cases that Delaware accepts from other states and vice versa. And there is a process that's involved. So a person can't just up and leave and go to another state.
Actually, you know what?
Okay, sorry, I'm giving it away.
You're giving away the answers to our questions.
Okay.
All right, so let's launch our poll on,
Okay.
on the Interstate Compact. Let's see, we are poll number 5. So question is if a person wants to serve their probation term in a state other than where they were sentenced, who can approve that transfer? The judge, probation and parole officer, the probationer, or the, oh, it cuts off my answer. This one is too long. So the sending and receiving state based on the federal Interstate Compact agreement. Just give another few seconds for answers. All right, we'll close it out and share results with you. So the question again was if a person was wants to serve their probation term in a state other than where they were sentenced, who can approve this transfer? And the correct answer is the last one, the sending and receiving states based on the federal Interstate Compact agreement. This is often misunderstood, and often people think that the judges can order the transfer, or that probation and parole officers can just approve the transfer, but it's a little more complicated than that. And Director Kearney is going to explain how interstate works a little more thoroughly for us.
So there's the Interstate Compact for adult offender supervision. That's the ICAS. That's what it stands for. And that link at the bottom is very helpful if anybody does have specific questions about interstate transfers. But it's federal regulations, and sometimes one of our state judges will impose an order that says this person's allowed to move to Pennsylvania, but we can't let them go even if a judge orders that. There's a process that's followed where it's done electronically through the ICAS system called ICOTS. And if a person, there are certain charges where it's a mandatory acceptance. So it's like felony level, certain misdemeanors where there's identifiable victims. There are certain crimes that they have to go through the process of doing the transfer. They can't just up and leave. They have to meet with their probation officer in Delaware. They have to pay $50, and that's something that's done by statute. It's not something that we have initiated. It's by statute that they have to pay the $50 in order to do the interstate transfer fee. They have to bring proof of their residence. So we can't just take a person's word that they have ties to another state and they want to move there. We have to have verification that that is in fact where they are planning on residing and where they have maybe resided before. So they can't leave the state until the other state accepts their transfer. So they can get reporting instructions and they can, but then they still have to go through the process of the transfer request. So if the other state, if say the person lives in Pennsylvania, they want to transfer to Pennsylvania and they go there, and then Pennsylvania does the investigation and the person is there in that state, they will automatically deny the case. So there are times that we essentially have to make people homeless in Delaware just to expedite the process of getting the other state to accept. People can't just up and leave, and it's a federal requirement. And then on our end, we do the investigations for incoming cases. So we investigate their home plans and make sure that they have ties to this area. And then we, again, formalize it through ICOTS and let other states know if we agree to accept case. And there's a lot of communication that goes on between interstate departments, especially with where we live in the tri-state area. Community service work program. So there's two different avenues that we have one resource in each office where they are in each county where they can go and either do community service. Say, for example, the court has imposed that a person does 35 hours of community service. There's coordination within each county within the probation offices where they refer people out for community service. People can also work off their costs and fines through work referral. They can't work off restitution, but they can work off their costs and fines. And, you know, if somebody is struggling with employment and finances, we can set them up through work referral instead of, you know, not paying anything towards their costs and fines. Next slide shows that the number of community service hours done 2018 to 2020. Again, you can see that the numbers got reduced in 2020 due to COVID. But it helps fulfill their financial obligations and, you know, gives some community service imposed to make the community whole. Next. Victim advocates. So again, in each district office where there's a domestic violence unit, victim service advocate, we call them VSAs. Again, we use a lot of acronyms. They provide contact information to victims where their perpetrator is on probation and parole supervision for domestic violence, sexual assault, or any kind of stalking related offenses. And they do outreach work, and then they contact victims throughout the supervision period to make sure there's no problems. And there's not always a no contact order. Sometimes there's a no unlawful contact order, but there was definitely a need to have a non-sworn officer reach out to victims so they feel more comfortable disclosing what's actually going on. They are a very supportive role. They advocate for victims. They go to court with victims. Again, they will do court accompaniments for new criminal charges, for PFA orders. They give them access or connect them with other resources, shelter services. There's something called Vine Link where victims can register if somebody's incarcerated, and they can get a notice if somebody is released, so they can hook them up with those resources and do a lot of safety planning. And I can say firsthand that I've dealt with some of these cases where the victim services intervention at that time probably saved some victims' lives. I mean, I can tell some stories, but it really has been impactful, and it's again a very necessary resource, and I'm so glad that it's statewide now.
We'll provide information on how to contact the victim services advocates through the statewide email and through each probation district office at the end of the program.
Yeah, and I mean, a lot of the police agencies have victim services, so it just goes along with, you know, us as a law enforcement agency also providing that support service.
Okay, next we have an overview of the task forces that we have at Probation and Parole. It's less than 5% of our probation officers are assigned to a particular task force. As you can see from the visual, we have officers that are assigned to Delaware State Police Task Force, Wilmington Police for Operation Safe Streets, Newcastle County Police, Operation Safe Streets, Dover Police, Operation Safe Streets. Then we also have FBI Task Force, DEA, and our U.S. Marshals. These task force officers, they provide enhanced supervision primarily for our higher risk offenders, but moderate and lows are not excluded. What they will do typically is there's a lot of curfew checks, community visits, home visits. They participate in community engagements. They will also assist with surveillance, help investigate violations of probation, execute arrests and searches as well.
And these members don't have caseloads. They assist the caseload officers with this enforcement piece.
Exactly. It's to enhance the supervision efforts of our caseload officers. Just to give you an idea of the percentage of task force administrative warrants in 2020, only 4% of the warrants executed in 2020 were for technical violations only. The other 96% of the admin warrants that were executed included a new arrest citation.
And I don't know if we went over administrative warrants, but that's basically, we can take someone into custody without the authority of the court. So we can arrest somebody right then and there if they're a risk to the community. So.
And if I could, just wanted to elaborate a little bit more on some of the misconceptions when it comes to task force and just give our audience just a general idea of the data. regarding their work. Like we said, 96% of the administrative warrants include a citation for a new arrest. 65% of those include a citation for a new arrest involving drug-related offenses ranging from felony level to possession of drug paraphernalia. And 32% of those administrative warrants include citations for new arrest involving a firearm, deadly weapon, or ammunition. A lot of people will, I've heard a lot about the, task force officers are arresting everybody just for curfew violations. The data actually shows us that less than 1% of our task forces execute administrative warrants, citing a condition number 13 only for failing to abide by a curfew. And those were supplemental violations to a more thorough violation. Another area to focus on with our task force officers are the number of firearms seized. In the past 2 years, our state task forces, which is our Operation Safe Streets and our DTF task forces, has seized over 600 illegal guns. And so in 2 years, those task forces have removed over 600 illegal guns from the streets and have confiscated over 245,000 grams of illegal drugs and narcotics. The graph in front of you will break it down year by year. If you could just go back, thank you. Break it down year by year. 2021, the data there only represents 8 months, the first 8 months of 2021, but the numbers will show you the amount of firearms that were seized for that particular year. Back to our case study. I'll start off, Jane Doe. Jane Doe has been doing well. She continues to be compliant. She has now submitted negative urine screens. They did a reassessment of her using the LSR tool, and she assessed at level 2. She was having a little bit of trouble paying her court costs and fines. So her officer referred her to work referral, where she was able to work off those additional court costs and fines. Finally, everything has been paid in full. She maintains her employment, and she is now seeking custody of her children.
All right, and Matt's not doing so well still. He's still missing his curfew even after he got off the GPS. And task force members have seen him in the area where he's not supposed to be, and he's hanging around with his co-defendants where he has a no contact order. And then Matt gets arrested for assault first and possession of a deadly weapon during the commission of a felony. All right, we're going to tell you how people get removed from probation. So there are many ways people can get removed. Sometimes people serve their whole probation term and they are, sentenced to a term period, and their term period comes to an end, and we write to the court and they are discharged per their maximum expiration date. So the next way people get off of probation is they can be in compliance, and maybe as a graduated incentive, they get discharged early from supervision. There's also a court order discharge where, a person could, have a status hearing or something and they're doing really well, and the judge at that point discharges them just per the court order or per their compliance. Earned compliance credit discharge, that's something where probationers earn 30 days of credit for every 30 days they're in compliance with their probation term, but it can't exceed half of their term. Certain crimes are ineligible for earned compliance credits, but we can do it quickly through our system if it could be without judge's approval, and they just, the officer will submit the earned compliance, and the supervisor will go ahead and approve their closure. So it happens swiftly. Technical violations are another reason. So if somebody violates the conditions that we went over besides getting a conviction, so anything that does not entail an arrest conviction, they can be discharged based on the technical violation. And that's through the court, where we take them back to court for a violation. Either we're issuing a summons or a KPS or an admin warrant, and they face the judge and we present our recommendation to the court. And so they can be violated based on conditions 2 through 13. Violation of a new offense, that's based on the condition 1 on the commission of a new offense. So those are the distinctions. Next slide. Do I do this one?
I can do this one.
Okay.
So just wanted to talk a little bit about the violation of probation reports and probation's responsibilities with that. Basically, it's our job to notify the sentencing authority of any alleged violations. And then with that report, we would make a recommendation for appropriate disposition. The next step from that, the sentencing court would then take the information that is presented from both sides, probation and the probationer, and determine whether or not a violation has occurred. And then the sentencing authority are the ones that would then determine and impose the appropriate disposition, whether that's finding the individual in violation, it could be continuing on probation, it could be discharging the probation. The outcomes can range, but that's typically what the process is. Probation officer presents the allegations based off of the information that probation and parole has, and then they would make a recommendation for a disposition. Courts would then hear both allegations and the argument against it, and then determine whether or not a violation has occurred, and then determine the outcome.
I know there's a lot of data on this, but it is good information. And again, I think Chief Taylor went over the misconception that we often violate people for smoking weed or for one curfew violation. And this data proves that that's not the case. Majority of our violations are based on condition 1, so they're based on new criminal offenses. A lot of times it's condition number 7. And, you know, in my career, I've seen a change from the use of cocaine to the use of opiates. And sometimes we have to take swift action because their addiction is so out of control and the treatment avenue isn't working. And condition number 9, a lot of times people then are, you know, if they're not complying with their probation, chances are they're not complying with the treatment components or any other conditions, special conditions that are imposed.
And just to add to that, Director Kearney, condition number 9 is not always just complying with a treatment program. Typically, a condition number 9, there's an identifiable victim, and the probationer continues to have contact with that identifiable victim, either lawful or unlawful, but it is a violation of the, so you're talking domestic violence cases, sex offender cases, where you've got identifiable victims, and that's going to look on a violation report as a violation of condition number 9. Likewise, one of the higher numbers that are on here as far as percentages goes are going to be a failing to report as directed. This doesn't just mean 1 or 2 missed office visits. Typically, that means the individual has completely absconded from supervision. I mean, stopped reporting for supervision and we can't find them. So those violations are also going to fall under that condition number 3 for failing to report as directed. If you take a look down at the bottom, it is a lot of data on one screen, so I can read it to you. But condition number 13, must abide by a curfew. In 2020, less than 10% of our violations included a curfew violation. Less than 10% of the violations in 2020 included a curfew violation. And
a lot of those curfew violations go along with the condition number 1. So a lot of times they're arrested for a new offense. It's after their curfew, so they're cited for both offenses. So one violation can include multiple conditions alleged.
Thank you. Back to our case study. Okay. I'll start off with Jane Doe. So Jane Doe has been doing well. She has 4 months left on her probation. She has been in full compliance, and the probation officer then writes to the court to request an early discharge. Court approves early discharge, and Jane is now off probation.
All right. And Matt, he got a violation submitted based on the fact that he was not complying A graduated sanction was imposed, but it didn't work because since that graduated sanction, he's continued to not abide by the conditions of his supervision. So in addition to him getting arrested, he's being cited for condition number 1 and for the technical violations. He's held on bail pending his violation. He finally goes before the judge. He gets sentenced to the new charges to 5 years, level 5, suspended after 3 years for 6 months, level 4 DOC discretion, followed by 18 months, level 3 probation. The court discharges Matt's violation of probation in light of the new sentence. So when Matt gets out, he will again be on probation for his new offenses.
Thank you so much, Chief Taylor and Director Kearney, for providing all of that information for us. We are going to start to move into the question and answer portion of our webinar, but we did want to take an opportunity to provide you with some information on different teams at DOC who might be able to help you with your questions, especially if we don't get to your question today. For questions about specific inmates or probationers, you can contact the community relations team. It's the bottom email on this slide. And again, we will make the PowerPoint available after the webinar. If you do contact community relations in reference to a specific inmate or probationer, please keep in mind that we cannot release personal or health related information on inmates or probationers without their permission. So if you do contact community relations, you will likely be asked your relationship to the individual that you're inquiring about, and we will have to look into whether or not we have permission to release information to you about that person. We've also included the victim services email box, and then additionally the phone numbers for each of the victim service advocates that are embedded in the probation and parole district offices in each county. And again, you can take a snap with your phone of this slide that's up, or we also make the PowerPoint available after we're finished. So I will give it another second in case anybody wants to take a quick little picture of this one. All right. And then future webinars that community members have asked for more information on are coming. So next month's webinar will be part 5 of our series, and we'll talk about sentence calculation and release dates. Really complicated, right? So calculating a court sentence and then calculating release dates with the different types of good time that are available. We have statutory good time, we have meritorious good time, we have bonus meritorious good time. And how much you get of everything depends on when you were sentenced and whether you were sentenced pre-truth in sentencing or post-truth in sentencing. So it's really complicated, for people who do it every day. So we understand that it's definitely complicated for the people in our custody in understanding it, for probationers understanding it, and for family and friends out there understanding when they can expect their loved one to be released. So we will have that in November. Please stay tuned for the actual date of that. And before we move to Q&A, we would just like to do one more poll. Again, a reminder that these polls are anonymous. We would like to gauge your satisfaction with this survey. So please rate how satisfied with this webinar. Please rate how satisfied you are with today's webinar. Again, we don't know who's responding. So, honest feedback is requested. And I'll give everybody a minute to respond to this, and then we will move on to the question and answer. Let's give it another few seconds. All right, and I will close it out momentarily. I really appreciate everyone who has responded. All right. Okay, thank you very much for that. And now we will move on to our Q&A section. All right, so we have gotten a lot of really great questions. We will try to get as many as we can. We have about a half hour left for time for questions. So let's start with, someone asked a question about what we are looking for in a probation and parole officer. So can we talk a little bit about people who might be interested in probation and parole as a career, some of the things that we're looking for in an officer, some of the qualifications?
Well, it has to be somebody who is easily adjustable because, again, like we both stated during this presentation, there's a lot of roles we play. We play prosecutor, we play counselor, we play assessor, we play enforcer. So somebody who's versatile in their skill set, somebody who's good with working with people, good communicator. Chief Taylor.
You're great. You're hitting it all. I think that it's very important to really emphasize the ability to be able to switch roles. Like we talked about earlier, you may come in with your mind set on doing a particular task, and without notice, you're switching gears and having to maybe it's get your equipment on and go out into the field. So you definitely have to be flexible for sure.
And insofar as education requirements, it's
60 credits for
60 credits.
College credits.
60 college credits. Okay, thank you. And then probation and parole officers go through a 12-week academy?
13-week academy, 13-week academy, and
a 6-week FTO program in addition to that to help transition from cadet to officer.
We typically run 2 academy classes a year.
And that's not a live-in academy. You go home at the end of the day.
Exactly. Yes. Good point.
Great. Thank you. We have a couple questions related to homelessness or who's homeless.
Yeah.
Housing instability. So what do you do when someone who is on the sex offender registry is homeless?
I'm going to defer that one to the chief. She worked in the sex
So
offender.
I used to supervise sex offenders for probably 10 years or more, sex offenders specifically. Homeless sex offenders does make it a little trickier, but not impossible. What we'll typically do is we'll just try to keep in close contact with him or her, whether or not it's enhanced reporting instructions to the office, or maybe the assigned officer is meeting up with him or her out in the community just to have more face-to-face contact with them to make sure things are okay. It also can involve calling in to the officer just to kind of check in, even if it's after hours, just to say, hey, this is where I'm laying my head at this shelter for this night, or but it requires good communication, but not impossible, even if they are on GPS.
Yeah,
So
so
our
tier 3s are, yes.
So statute requires any offender, sex offender that is a tier 3 sex offender, while they are on probation with us, statute requires that they wear a GPS anklet. That does not mean that they cannot be homeless. We encourage stable residents, but it doesn't mean that they cannot be homeless. They would have to make accommodations to make sure that the equipment is charged. That could be coming into our probation offices and the lobby and charging it there. Maybe it's a work release facility. It could be, a Dunkin' Donuts or a family member's house, friend's house. The equipment does require the battery to be charged every so often. That's the only requirement, and that they address any sort of technical issues with the equipment.
And we have sex offender treatment in-house too. So there's a lot of coordination with the treatment providers. I know it doesn't really apply like with the homeless situation, but there's a lot of communication. There are a lot of occasions for the offender to be reporting to our office.
And again, the only time homelessness is not appropriate is when somebody is sentenced to level 4 home confinement. That's the only time. Now, with that said, some people will claim to be homeless just to avoid having home visits when actually they are consistently residing at a particular area. They just don't want probation to go to that particular area. So, excluding those 2 situations, homelessness is not a violation at all.
And that's where our investigative skills come into play. If you're continuously going out to a residence and you know, you finally get a neighbor saying nobody lives there, or that person you're looking for does not live there. You know, so you use your resources from, you know, reports from the community, and you try to pin down where the person is. But it could be, okay, you know what, you're going to be placed on GPS. I'm doing a graduated sanction. I can't account for where your location is. So we need to be able to monitor you 24/7.
And I think, you know, as a general rule, right, as the Department of Correction and the state of Delaware as a whole, we do not have sufficient resources for our homeless community, right? We don't have beds and shelters are limited.
Especially for our sex offender population.
Right. So yeah, vouchers are limited, right? Assisted housing is limited, and even more so for the sex offender population. It's very difficult to find an organization who is willing to work with sex offenders. So it is a struggle. Another question we had is about hosts, right? So if an offender is at level 5 and they don't have a host to stay with at the time of their release, the question was posed, their release to level 3. But someone who is coming from level 5 to level 3 isn't required to provide or isn't required to necessarily have a specific host that's approved by the department. If your sentence is that is following your level 4 is a level 4 sentence, there is some host approval processes. So what does probation and parole do if someone is at level 5 with a level 4 sentence to follow, and there is not they don't have a host or an appropriate host?
I'll take that one, Missy. So let's say the order reads level 5 and then it's followed by, 6 months level 4 home confinement, and the individual does not have either a host or not an appropriate host. What the officer would then do would write a report to the court, typically explain the situation and ask for DOC discretion. That could look like a work release sentence as opposed to a home confinement for that quasi incarceration, because home confinement is quasi incarceration, just like work release is quasi incarceration. Or the courts could even at that point, once they have the information, they could modify the sentence and put the individual out on level 3 supervision, where a approved host is not a requirement. Their actual address in our system would say homeless, and then we would take those extra steps to try to maintain good contact and communication with the homeless probationer.
Thank you. Okay, so let's see. We have a question about probationers who have a mental health diagnosis. And then additionally, there was another question to talk a little bit more about mental health court. So do you know, and this may not be something you have off the top of your head, but you might be able to speak to it generally, what percentage of probationers have a mental health diagnosis? And how do probation and parole officers become aware of diagnosis?
We don't always have that information. I think that one of the things that we are looking to improve upon, especially with the transition accountability plan that we're rolling out in the very near future, is sharing the information from even within our own department, from maybe one particular area to the next, where we have those diagnosis information sharing with the whoever owns the case at that particular time. We recognize that as an area for improvement, and we're definitely making steps to improve that communication.
Yeah, and I don't think we have data on the number of people who suffer from mental health. I mean, sometimes it's based on self-report, and getting to know the offender and the probation officer, asking the right questions about their history of diagnosis, any medications they're taking. Mental health court is, and I'm not sure what the diagnosis, you have to be eligible, and it has to be some access diagnosis, and I cannot recall what it is, but it's kind of like a pre-adjudication where somebody agrees to enter the mental health court, and there's a mental health court officer who is directly connected to the mental health judge, and they have status hearings, and they talk about compliance and that sort of thing. So there's a lot of hands-onness with the mental health court, the officer, and participation with the court and reporting as to how they're doing with treatment. A lot of dual diagnosis. Sometimes it's hard to decipher from the substance abuse and the mental health.
And as Chief Taylor was talking about, if someone's coming to probation from a period of incarceration and they have mental health diagnosis, that information, we're going to be able to have that information kind of flow back with them into the community if they're being evaluated and treated by our behavioral health providers while they're incarcerated. Probation and parole will be aware that there is a mental health diagnosis so that we can, work on continuity of care from the institution back out into the community. But it is difficult in situations where people are being sentenced directly to probation, which is a frequent way that we receive cases directly from the court. So we may not have very specific information right away. And it is questions about mental health are asked during the LSIR assessment. So it is something that we query about, but if someone comes directly from the court and didn't come from one of our institutions, we may not have very specific information really other than self-report. So thank you. All right, so here's a question about the $200 supervision fee. What is the purpose of that fee, and can it be seen as an undue burden? And what would you do if someone didn't have the ability to make that payment?
So there is pending legislation to address the $200 supervision fee. It goes into general fund, so it's not like the probation officer, gets a bonus for collecting the $200. There are ways that the supervision fee can be waived if somebody's receiving public assistance. It's just a matter of the, there's certain criteria that they have to follow for a waiver, and the probation officer can request the waiver and it's approved by their supervisor. So.
Thank you. Okay, let's see. How many strikes can someone have before given a graduated sanction or an increased level of probation?
Again, it depends. So graduated sanctions, a graduated sanction can be a verbal warning. It doesn't have to be that, they're placed on GPS or some kind of commitment or reduced in their curfew. So it's progressive. So an officer can, first address, a non-compliance by just having a counseling, graduated sanction. So then it builds up, of course. So it depends on how many times the person's doing that violation. If it rises to the level where it could rise to the level where the violation is something that we can't address in a graduated sanction, that we have to address in a violation. And generally, when we do violate somebody, the percentac, they only go up one level. So if somebody's on level 2 and they're non-compliant and we take them back to court for a violation, we're asking for level 3. Level 3, we're asking for level 4. People get flowed up still because of the assessment tool, and that's based on their risk and needs. So that's something completely different that they could be potentially flowed up for because of their assessment. They are determined to be a high risk person. And again, we're trying to meet the offender where their needs are so that they don't mess up. And sometimes that requires more supervision.
And one of the other things, we talked about graduated responses and graduated sanctions. One of the tools that we have for graduated sanctions is what we refer to as our administrative commitment. Code gives us a certain number of days per calendar year that we can administratively commit somebody to one of our level 4 facilities to address, the minor technical violations, which our probation officers have done a fantastic job at really using that as a tool to address those appropriate technical violations. If we pulled up the data right now, you would just see this incredible spike in the use of that, and alongside with that, you can see the reduction, like we've shared the stat with you on the violations, the reduction in the technical violations on our violation reports.
Thank you. We have a question about pretrial supervision. So we talked about the levels of probation supervision and how they're determined. How do you make a decision on how to supervise someone on pretrial supervision?
Okay, so when the bail reform happened, the DELPAT was created to determine people's, well, actually, like the judges use it on the bench to determine if somebody should be released, if somebody should be placed on pretrial, if somebody should be released on unsecured bail, conditions of bail, that sort of thing. So we took that tool and modified it to determine our risk levels once they get to pretrial supervision. And there's 3 levels. So there is administrative, there's standard, and there's oh my gosh, enhanced. Thank you. And the DELPAT is based on new criminal activity and failure to appear rates. So it's a nice colorful chart that helps determine bail, and then helps us determine the level of pretrial supervision a person is imposed, gets how they are supervised based on the DELPAT score. It's also based on certain criminal offenses. So they're called signal offenses. There are certain offenses that automatically go into the higher category. So
it's a combination of the risk assessment that's done by the judicial officer setting the conditions of release, and then the list of signal offenses that were developed during pretrial reform. And pretrial supervision, right? The goals of pretrial supervision are to avoid pretrial failure, right? Which is defined as the likelihood that you're going to fail to appear in court, or the likelihood that you're going to commit a new criminal offense while you're released. So this Delaware pretrial risk assessment tool is going to provides us with 2 scores. It provides us with a risk of failure to appear score and a risk of new criminal offense score. And probation and parole for pretrial supervision takes those scores, takes the signal offenses, and it gets fleshed out into one of those 3 categories based on your risk of failure to appear or your risk of reoffense. And there's been recent changes in the Title 1121, the release of persons accused of crimes. There's been SB 7 kind of made some changes as to a requirement for cash only bail being set at initial presentment for certain signal offenses. So we are, we're determining now, we're waiting to see, that was effective at the end of July, what kind of effect that's going to have on our incarcerated pretrial population and then our pretrial population in the community. So we have a question about in what cases would probation and parole require a polygraph test for those on probation?
I'll take this one. We do use polygraphs for treatment purposes for our sex offender population. We typically have 3 types of polygraph. We have our denial polygraph, which would be somebody that has been convicted of a sex offense and they deny that sex offense. We'll use that polygraph to determine, sort of direct the treatment needs for him or her. Then we have our criminal history, a sex offense history polygraph. So again, this is for treatment purposes. Let's say somebody is enrolled in sex offender specific treatment. They deny any sort of deviant sexual interest or arousals. We will use that sexual history polygraph again to determine the treatment plan for that particular individual. And then lastly, we have our maintenance polygraph. So those are typically a sex offender that has been engaged in sex offender treatment for quite some time. They will do that maintenance polygraph to determine where they stand with their treatment progress, how compliant they have been with their treatment plan. And again, that's used to help drive treatment outcomes. So to answer the question, it's a sex offender treatment tool used for our sex offender population.
Thank you. Okay. Sorry, I'm just scrolling through. So there was a question about There's a question about a graduated sanction where you have the ability to sanction someone to 5 days at a level 4 facility as a graduated response. And the question is could someone?
I briefly talked about that a little bit. That's our administrative commitments.
Mhm.
And generally, they just do a weekend. They report
and
it on
it's-
Friday and they are released Sunday
And it's not a level 5 facility. It's a level 5. It's a level 4
for work
facility.
release.
So if someone was being sanctioned with an administrative commitment, they would not be taken to a level 5 facility and inadvertently serve those 5 days at level 5. They're taken directly to the level 4 facility if it's an administrative commitment.
They usually self-report. So, they discuss the violation, the officer and the offender. They get a notice that they are to report to usually, in Newcastle County Work Release Center, to the Plumber Center by Friday at 5:30. And that communication goes through to the level 4 facility. And the person reports there, does their weekend sanction, and is released that Sunday.
And typically while they're serving their weekend sanction for that technical violation, we tried to incorporate cognitive behavioral therapy. It's a CBT, short-term CBT program that they did during their weekend stay. Of course, when COVID came along, that sort of put a kink in that process. Now with the COVID restrictions lifting, we're able to start reintroducing that particular CBT program for our administrative commitments on the weekends. Again, it's another graduated response and a way for us to avoid returning the individual to court for a violation.
And if someone was, is there a situation where someone would be administratively taken to a level 5 facility? So could that be, if someone was arrested on an administrative warrant for a violation of probation, could they be taken directly to a level 5 facility?
Yes. So again, we talked about the administrative warrants when we were talking about the task forces, but any sworn officer has the ability to do an administrative warrant. So basically that's taking the person into custody right then and there for the violation, and we can bring them right over to the institution if the courts are closed. So they have a bail hearing then after that. So it's not like we bring them in and we just have them sit there. So there's coordination then with the courts to have a bail hearing, and they go before a judge. Usually it's via video bail from the level 5 facility. And the judge can either, set an unsecured bail and they're released pending their violation, or they are, held in custody until their actual hearing date.
Thank you. There is a question. Let's see. Again, another question about homelessness. Do you, and you may not be able to provide percentages, but they're asking about a percentage of people on probation who are homeless. And a second part of the question is, do you feel like that has increased as of late, or if it's kind of remained the same? So if you can't talk about an actual percentage of people who are currently homeless on probation, can you talk about if it feels like it's increasing, or if it's decreasing, or kind of staying the same?
I feel like it's staying the same. Yeah, I don't know if there's any changes, and it's hard to determine like how you're going to classify someone as homeless or like temporarily homeless. Again, we have those people who avoid us by saying they're homeless and they're bouncing from place to place, or they're not staying where they're saying they're staying. So it's hard to differentiate between those two if you're doing a head count of who is actually a homeless person. Again, we try to provide support services for those people, hotel vouchers, that sort of thing, and try to avoid that if we can assist in that matter. There are resources. Again, they're limited resources, and they're even more limited for homeless sex offenders.
Yeah, so that was another question that kind of came up, what financial assistance might be available to help homeless offenders in general and sex offenders specifically. And, you kind of touched on the fact that there's been some grant funded subsidies for kind of emergency housing. If we have someone who, we know that doesn't have somewhere to go. And while the in-reach coordinators and the department's reentry team is kind of working on a plan for housing, we have limited grant funds available to help with emergency housing assistance, and that money's only there as long as there's kind of money left in the pot from the grant. So it's difficult. We do have right, we coordinate with other state agencies and other organizations for shelter beds and for halfway housing. So it's coordination between the different entities. We have our contracted provider, Centurion, has reentry coaches that work inside of the facilities. We have the correctional counselors inside of the facilities who are working on reentry planning, and then Probation and Parole has their in-reach coordinators who assist, on the way out, and they kind of all work together to identify what resources might be available. But financial assistance for housing and housing and financial assistance for sex offenders in general is it's an area that is lacking, and again, lacking not only for offenders but lacking for I think just the state in general. Let's see. There was a question about conditions of supervision. So a probationer has their conditions of supervision reviewed at intake, and then probably again by their probation officer when they meet them. Is there an expectation that they are provided a copy of their conditions of supervision? And if so, and they don't receive it, what should they do?
They are provided a copy. So when they get signed up for probation, whether it be institutional release or through intake, they get a copy when they initially sign up. If they need a copy, they can always ask their probation officer. There should be a signed copy in the person's file.
Thank you. All right, we are coming up on 3 o'clock. We've had a lot of great questions. I think there are still some in here that we're not going to have time to get to, and or that might be better answered offline. So we have, I know that Deputy Chief Klein has been kind of answering questions in the Q&A as we've been going along, and we've tried to hit as many of the questions as possible. But I think that is all we will be able to kind of answer live on the webinar. We will follow up with any questions that we can answer offline. And again, I will go back to, before we hop off, I'll go back to the slides with the contact information, so that if you have any other questions, you can reach out through one of these mailboxes, or also additionally, if you go onto the Department of Corrections website, you'll be able to find contact information for all the probation and parole district offices, and for numbers here for DOC Central Admin that you can reach out to. I want to thank Director Kearney and Chief Taylor for providing us with information on probation and parole, and I hope that everyone learned something and felt that this was a good use of their time. And I hope that everyone can join us again in November for sentence calculation and release dates. And thanks everyone for joining.
Thank you.
Thank you.
All right, thank you. Oh, and again, we will, certificates will be available, and we will make the recording and PowerPoint available.